started with our meeting today. We have a couple of bill hearings. Let's check to make sure we've got Natalie. We do. So I'm going to open the hearing on House Bill 2362 and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2362 modifies the elements of and makes changes to the criminal penalties for the crime of abuse of a child. The bill amends KSA 215602, that's the current abuse of a child statute, to provide that abuse of a child would be committing any of the following acts against a child who's under 18 years of age. Knowingly torturing, cruelly beating, cruelly striking, or cruelly kicking, knowingly inflicting cruel and inhuman corporal punishment, knowingly using cruel and inhuman physical restraint, recklessly causing great bodily harm, abuse of head trauma, permanent disability or disfigurement, knowingly causing great bodily harm, permanent disability or disfigurement, knowingly inflicting cruel and inhuman corporal punishment with a deadly weapon, or knowingly impeding the normal breathing or circulation of the blood by applying pressure on the throat, neck, or chest, or by blocking the nose or mouth of the child in a manner whereby death or great bodily harm could be inflicted. The criminal penalty for the acts up in paragraphs 1 through 3 would be a severity level 5 person felony if the child is at least 6 years of age, and a severity level 3 person felony if the child is under 6 years of age. The criminal penalty for the acts described in paragraph 4 would be a severity level 4 person felony, and the criminal penalty for the acts described in 5 through 7 above there would be a severity level 3 person felony. And I can take any questions.
Thank you, Natalie. Any questions? Don't see any. So we will begin with proponents, and Todd Thompson is back with us today. Welcome, Todd.
Oh, thank you. Thank you, Chairman. Thank you, committee members. I appreciate this opportunity. We did attempt to get this bill passed last year. I believe there were some compromises made, and I believe that's what's put in front of you. This bill had come to my personal attention, and I should introduce myself. I'm sorry. I know I've been in front of you before, but I am the Leavenworth County Attorney. I am representing today the Kansas County and District Attorney Association. This is one of our bills that we find to be one of the most important ones of the legislature. Maybe not as important as the speedy trial one, which we appreciate, but of course, this is very significant to us. In researching and how to propose the bill, myself and members of the Sedgwick District Attorney's Office worked diligently to come up with a strategy that is better than what we have for the abuse of the child statute. I say this because in 2018, and then the case got resolved in 2019, we had a 3-month-old baby beaten, pushed off at a couch to the point that it had 31 broken bones. At the time that we had dealt with the young child, it had 24 broken bones current and then 7 previous breaks. It was horrific. It was significant. It was heart-wrenching. We went to try to find charges, and obviously, and probably to the most of you would think, well, you would charge abuse of a child, right? Well, the problem with that was there was only significance of the abuse of the child would be of torture, of capturing or putting into a cage, of things of that nature. We could not rise to the level for what we had, which was basically an aggravated battery, which was a higher punishment. It was a level 4. For child abuse, it was a level 5. We didn't think that was right. Obviously, this child, much less any of our small children, can't defend themselves like they should against their parents, or in this case, or other people. And what we wanted to do is make it commensurate with the seriousness of this. I did look at the fiscal note. It's not significant. I know one of the things that you always have to think about is what the bed space impact would be. This one is not that much. It is 3 in the next year or 2 and 4 or 5 by the next, looks like almost 10 years. I don't think that's significant enough for what the type of case and type of crimes that we're seeing with this. I'm not going to say we see these always, but the option of only charging a count that really isn't what is best for this is not right. We need to have something that is smarter and better and protects our children. And that's why we are offering it to this day. I stand for any questions. I appreciate the opportunity to speak.
Any questions, committee? Not seeing any. Is there anyone else here today as a proponent or online? Anyone as a neutral conferee? Representative Humphreys.
Thank you, Mr. Chairman. Just looking at the bill, and I'm sorry, I couldn't find the bill brief to pull it up. I'm sure it's in my email, but could you explain just a little bit further about it? It seems like the mens rea, the mental state is really what you're adding here a lot. I mean, as far as when I look at the changes in the bill. And so could you explain that just a little bit, the reasoning and just kind of the intent?
Well, the reasoning is the initial bill only allowed for things like torture and capturing things of that nature. It didn't really take into the account of actual aggravated battery like physical beating, I would say. And in doing that kind of made it really difficult for us to be able to charge. And when you talk about the mens rea, or what the possibility is, it's basically abuse to a child. And so we felt that that if you're going to have a charge which is abuse to a child, and there's some case law out there that you're supposed to charge what's most appropriate to what the given statute. And so the most appropriate, generally, when you have a child abuse type case, would be abuse of the child. The problem is the severity level of that abuse of the child is actually only a level 5, where if someone would say stab, shoot, or hurt significantly with great bodily harm or likely cause death, they would get a level 4 charge. It made no rational sense of why you could beat a human, adult human, and get a level 4, where you beat a child and you maybe, or torture a child and maybe only get a level 5. What we're trying to make is a more rational sense to statute for abuse of a child, that if you would do something like that, it could look at a level 3, particularly of the age. And there's a category for 6 and under and 6 and over. I hope that answered your question.
Yep, just reading through the bill a little bit more. Okay, thank you. Thank you, Mr. Chairman.
Committee, any other questions? Is there anyone else? Let's see, I don't think I asked for opponents. Any opponents? Not seeing any. We will close this hearing and move on to House Bill 2365.
Thank you, Chairman. Thank you, committee.
Thank you. And have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2365 provides immunity from prosecution for possession of a controlled substance or drug paraphernalia if that person is seeking medical assistance related to substance use. So the bill would enact a new section of law to provide that a person and up to 4 other persons acting in connection with that person are immune from prosecution for possession of a controlled substance or drug paraphernalia if the person initiated contact with law enforcement or EMS because the person reasonably believed they were in need of medical assistance and then cooperated with law enforcement or EMS, or they initiated contact with law enforcement or EMS for another person who reasonably appeared to be in need of medical assistance, provided their information to law enforcement or EMS, remained at the scene with that person needing assistance, and cooperated with EMS or law enforcement, or was the person in need of assistance under that paragraph 2 provision and cooperated with EMS and law enforcement. Subsection B provides that a person shall not be allowed to initiate or maintain an action against a law enforcement officer or agency for compliance or failure to comply with this section. And except in cases of reckless or intentional misconduct, law enforcement officers would be immune from liability for arresting a person who is later determined to be immune from prosecution under the provisions of this section. Subsection C provides that the section does not apply to a person seeking assistance during the course of the execution of an arrest warrant or a search warrant. Subsection D provides that nothing in the section precludes a person from being prosecuted on the basis of evidence obtained from an independent source. And subsection E provides that no property that is seized by law enforcement during an encounter that results in a person being immune from prosecution under this section would be subject to civil asset forfeiture. And I can't take any questions.
there any questions for Natalie? Not seeing any.
Chairman, I do have questions.
Oh, I'm sorry. I scrolled down and I don't see your hand. Representative Carmichael.
Okay. Thank you, Mr. Chairman. Ms. Scott, this bill is familiar to me, not because we've heard it before, but because a couple of years ago, maybe a little bit longer after some serious work on the part of this committee, we passed what's known as the 911 Good Samaritan law with respect to juveniles in possession of alcoholic beverages who call for medical assistance. I think this bill is essentially the same bill, but with two substantive changes. First, that it covers victims of substance abuse rather than irrespective of age, as opposed to alcohol and minors. And second, that it extends the immunity to up to 4 persons assisting the person who is in crisis, as opposed to 2 persons under the Juvenile in Possession 911 Good Samaritan law. Am I generally correct in those understandings?
Yes, Mr. Chairman. I was trying to find the exact statutory citation for that one, and I'm not finding it right now. But yes, we did enact something very similar to this. We patterned this bill off of that statutory provision related to minors in possession of alcohol. If they, or like you mentioned, 1 or 2 other people call police in order to help someone who might be suffering from alcohol poisoning or something like that, needing medical assistance, then they would be immune from prosecution for a minor in possession.
And I might add that Ms. Moyer looked that statute up for me last Thursday or Friday, I think it was, and I can't find it on my messages right now, but we'll get it soon.
Other questions for Natalie? Okay, we will move on to proponents. Our first one is Lisa Veda. And Lisa is online.
Thank you, Chairman Patton and esteemed members of the Kansas House Judiciary Committee. My name is Lisa Veda, and I'm a pharmacist from Wichita, Kansas. And I've worked diligently for many years battling this horrific opiate epidemic. And I know many of you from my work on the naloxone bill in 2017. But things have changed since then. We are seeing synthetic opiates, mainly fentanyl. They're deadly, and they're cheap, and they're showing up in street drugs everywhere. And just to kind of give you a little bit more information, 1 ounce of pure fentanyl is enough to overdose 14,000 people. 1 ounce, 14,000 people. I'm telling you pharmacologically that 1 dose of naloxone usually isn't enough to overcome the effects of these potent opiates. And it's taking 3 to 4 vials of naloxone to counteract the effects of these very potent opiates. And people don't have that on hand, and thus they need to call for medical assistance, but this isn't always happening. A friend of mine lost her 20-year-old son, her only child. He was at a friend's house. She talked to him at 9 p.m. And the people there at the house knew that he had taken some drugs, but because of some prior issues and drugs being present, they didn't call 911 and instead put him in a guest bedroom to sleep it off. When his mom called the next morning, they found him dead. So now on Mother's Day and his birthday and during the holiday season, these are no longer joyous occasions for this still grieving mother. Recently, I heard a Kansas woman give her account of losing 3 friends in 2020 due to drug overdoses. And once again, emergency help was never sought. I also heard of accounts of people being dumped in bushes in front of our local hospital emergency department, just being dumped there. People have said to me, Lisa, sometimes a person needs to hit rock bottom and go to jail before they're willing to change and get help. But I'm telling you that with these potent synthetic opiates, we may not be able to help them because 911 wasn't called and we weren't even given a chance to save their lives. As Representative Carmichael stated, the similar bill was passed in 2016 that was applicable to the minors who became ill after consuming alcohol and those who seek medical attention. The Kansas law enforcement provided written testimony that they have not encountered any problems with application of this law and don't expect any with this House bill that we're proposing. Also, just so you know, these situations don't happen just to young people. The fastest growing group of people becoming addicted to opioids are older women. Grandma has arthritis, nobody wants to see her in pain, and she's been given prescriptions for opioids. And then grandma gets confused, she takes too many, and there may be other older family members who are afraid to call for help. In conclusion, we don't always know why someone doesn't seek medical attention in an overdose situation. However, passage of this bill would remove the barrier of fear of arrest and possibly more importantly, save a person's life. Thank you.
Any questions, committee? Not, we will move on to our next proponent, Seth Dewey.
First of all, I want to thank you very much for the opportunity to speak and for taking the time to consider this vital proposal. My name is Seth Dewey, and I work for the Reno County Health Department. I work in the health education field, especially with substance abuse, and serving as the project coordinator for several grants dealing with substance abuse. We've worked tirelessly with multiple partners from all backgrounds, from school districts to law enforcement, from medical professionals and fire and EMS to the business and industry sector. We've realized that while our community coalition work has had success, we also know that there is more to be done locally and, of course, statewide. 258. 258 is the number of Kansans that we lost to overdose in 2019. Now, this is taken from KDHE's website on mortality data. This is also only from January to September of 2019. So we know that the number in actuality is higher. If people felt safer calling 911 in the event of an overdose, who knows how many lives could have been saved? And in actuality, wouldn't have one been worth it? Another area where we could benefit from this proposal is more calls to 911 not only increases the chances of saving a life, but it also will help us to get more data on overdoses, ED visits, and substance trends, similar to the fentanyl trend going on, that can assist those in public health and coalition work to be able to keep up with this ever-changing work and to refocus our prevention, education, and treatment strategies throughout our state. I ask that we all keep in mind the premise that underlies Good Samaritan laws. Its origins, of course, being traced back to the ancient biblical parable, ultimately yielding the definition of a Good Samaritan as an individual who intervenes in a time of need to assist another individual without prior notion, responsibility, or promise of compensation. This presents us with an issue to consider with grave seriousness. We constantly are encouraging and giving praise to those that act in times of crisis and take quick action to save a life. We see the stories on news, in the newspaper, and on social media. Ones that call 911 in the event of an overdose are making the right call, the morally right call. It is unfortunate when fear of prosecution or reprisal would make a person question the morally right decision. As I already stated, my name is Seth Dewey, but I also am a person in long-term recovery. And what that looks like for me is I haven't felt the need to use a mind-altering substance or alcohol since July 23rd of 2017. Since that time, I have attended more funerals than I had previously in my entire life. Some of these were ones that I knew in my previous life, and some were ones that I had met in the recovery process. I have talked to so many parents and family members who are trying so hard to come to terms with the loss of their loved ones, knowing that they passed away alone, wondering if there could have been something done different somehow. In conclusion, I want to thank you all for the time and the work that you do in considering all these proposals, but especially this one. Please know that this bill, 2365, will save lives. It will help us collect vital data and information that we can use in prevention and education work. And it will be another step in tearing down some of the stigma that continually puts up barriers between people who use drugs and those like us that are trying to help. Thank you so much for the time and consideration.
Questions, committee? Not seeing any. Committee, you've been emailed out some written proponent testimony from Ed Klump on behalf of his 3 organizations, from Daniel Warren, Bobby Cram, and Julie Ann McLeod Powell. Is there anyone else here or online as a proponent? Okay. Are there any neutrals? Don't see any. We will move on to opponents, and we have Greg Smith online.
Thank you, Mr. Chairman. Representative Carmichael, I think the statute you were looking for is KSA 41727.
That was not my request, sir. I didn't ask for any statute numbers.
Well, you had talked about a bill in 2016, I believe, Senate Bill 133, which was the Juvenile 911 bill.
Yes, the reviser has that information, sir.
Anyway, Mr. Chairman, that bill was directly impacting juveniles and not just any person. And back then I was a senator and I supported that bill. But in talking with our sheriff here in Johnson County, we cannot support this bill because of the magnitude of people that it covers. We have no problem supporting a juvenile version of this bill. It's well known that critical parts of the brain involved in decision-making are not fully developed in humans until approximately age 25. But once you're over 25 years of age, you should know or do know that using these types of substances can cause you bodily harm or death. Basically, this would just take away the intent for any type of drug crime. All you have to do is call the police or call MedAct and report that you have a medical emergency due to the drug. Now, that's not to say that we're not interested in that. If we were any call we respond to, that's one of the first things we look for. We carry the antidote for all the different types of drugs. Fentanyl has become a huge issue. And the one person that testified was correct. Sometimes one dose doesn't do it. Sometimes 2 doses doesn't do it. And so our primary function in that circumstance is still the saving of a life rather than prosecuting a crime. However, this bill is a little bit different than Senate Bill 133 was back in 2016 when it comes to immunity for liability for law enforcement. We would be more comfortable with the language that was used in Senate Bill 133, which says that a person shall not be allowed to initiate or maintain an action against a law enforcement officer or such officer's employer based on the officer's compliance or failure to comply with this subsection. This current bill does not provide that type of protection and no protection at all for the employer. It specifically mentions the officer. As I said, we would be more than willing to work on a juvenile version of this bill, but we can't support the bill as it's written, and I'm happy to stand for questions.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. Deputy Smith, does the Johnson County Sheriff's Office believe that it is so important to successfully prosecute drug crimes that it is preferable for victims of substance abuse to suffer the death penalty so as not to impede your investigations?
I wouldn't characterize it that way at all, Representative. Getting the drugs off the street will keep it out of the hands of people from using it, and that is part of the duty that we're charged with. But as I said, if we respond to an area or to a call where someone is in danger of dying, we will do everything we can to prevent that from happening.
And one final follow-up, Mr. Chairman. For how many years has the Johnson County Sheriff's Office attempted to get drugs off the street, and have they been successful?
Well, Representative Carmichael, Chairman Patton, I suppose that's a matter of opinion.
Thank you, Mr. Chairman.
Any other questions, committee? Representative Wheeler with a question for Natalie.
Thank you, Mr. Chairman. Natalie, on page 2, the subsection D, it says nothing in this section shall be construed to preclude a person who is immune from criminal prosecution pursuant to this section from being prosecuted on the basis of evidence obtained from an independent source. Natalie, can I ask you to expound on what you believe this means as an independent source?
Mr. Chairman, what I understand that to mean, so we're talking about immunity from prosecution for either possession of a controlled substance or possession of drug paraphernalia. So if a law enforcement officer, let's say I'm calling, I think my friend has overdosed on drugs, and so I'm calling law enforcement, and they come, and when they show up, I have drugs in my possession. That is what is creating the immunity here. Now, if they already had some other evidence that I was in possession of drugs 4 days ago in a different scenario, and they had probable cause enough to arrest me for that violation, I believe that that's what it's trying to say, is that if they have independent evidence from a different source other than the interaction they had with me during this encounter, then there's nothing to preclude them from proceeding with a prosecution.
Mr. Chair. Suppose this scenario, a person who is at risk of collapsing on overdose of fentanyl is walking down the street with his good buddy or his girlfriend or ex-girlfriend. And the police arrive, or whoever arrives, that person, independent of the person laying on the ground, says he's got drugs on him and needles. Is that person, other than the victim here dying of fentanyl overdose, an independent source?
Well, Mr. Chairman, and I'm not totally sure I'm understanding the question. Are you, so if you're asking whether that person who was walking down the street would be immune from liability in that scenario, it sounds like the law enforcement officer just happened upon this situation. The person, in order to qualify for this immunity, you have to either have initiated contact with law enforcement or EMS, or been the subject of a call initiated to law enforcement or EMS. But yeah, if I was walking down the street and I saw someone who I thought was overdosing on drugs, and I called the police, and when the police came, I was in possession of drugs, that is who this bill is targeting for immunity, so that I don't get in trouble or I don't get prosecuted when I was seeking help for someone else or myself.
Chairman, pursue one more. Let's hypothesize this scenario. that a person walking down the street and ready to collapse on an overdose of fentanyl before going unconscious calls the police or calls 911, and a response is sent out, and the person friend walking along with this person, now collapsed and unconscious on the sidewalk, says he's got fentanyl and needles on him back at the house or on his person. Is that person, see, I'm really distinguishing between the person suffering the tragedy versus someone who just knows something about it.
Right.
As an independent, so that's a very nebulous term.
Yes, I believe that the intent is that information that's obtained as part of that encounter can't be used for prosecution. It has to be from a completely independent source.
You think of some way we can say that and not independent source?
We could certainly work on that.
Thank you, Natalie.
Any additional really hard questions for Natalie? Do not see any, so we will close this hearing on 2365. Okay, committee, that is it for today. Tomorrow we have two more bill hearings, and I had Kathy send out a revised agenda saying hopefully we have time to work on bills. So while everything we have heard is a potential, here is a list, about half the list that we need to still get to, that I'm going to list off for tomorrow. You've probably already have this written down for the most part from last week. The first one is 2390, which is the annual open records exemption bill. 2154, which is the school bus stop arm bill. 2227, which is the Chief Justice's power. 2369, closed case task force. 2228, the sex assault kit from the KBI bill. 2292, Secretary of State's open records, and 2363, which is the bids bill we heard last week. Again, the list is much longer, but we'll start there. Just also to give you a little heads up, on Friday, I think it was Friday, I requested a bill be introduced in Fed and State dealing with the Kansas Emergency Management Act. Natalie has worked nonstop all weekend trying to get something ready that we can turn in, and hopefully that happens tomorrow. So it will be introduced tomorrow. You will all have hopefully plenty of time to begin digging into it. I intend to add a hearing to Wednesday, but that purpose of that hearing will simply be for Natalie to do an overview and for us to ask questions of Natalie. We won't get to proponents or opponents on Wednesday because I want people to have sufficient time to be able to review it before they're required to submit testimony as to whether they support it or not. So that will be added to Wednesday. Again, this is all contingent upon it being introduced tomorrow. And then Thursday and potentially Friday, we will have hearings on that bill. So I will keep you all posted as I know more. When you get it, feel free to give me your feedback. It's probably that, Goldilocks syndrome, not enough for some, too much for others. Maybe that's a good spot. We'll see where we end up. My understanding is the Senate, while I have very little idea what they're going to have in their bill, I think they're doing something similar. So we'll hopefully have that in the next couple of days. And my understanding is the governor may have a bill as well that gets introduced. So this could turn into chemo week fairly quickly. And as I know more, I'll keep you all posted, but that's what I know at this point in time. And I'll do my best to keep you abreast of changes that I find out. So come tomorrow ready for two bill hearings and those bills that I listed off. And then the rest of the week, we're going to be flexible and do what we have to do to keep the process moving forward. Because as we all know, March 31st, the chemo extension bill that we passed sunsets, so does the disaster declaration. And so we've got some things that we need to deal with before then. So clock is ticking. I'll keep you all posted. Thank you all for your attention today. We'll see you tomorrow.